This is my favorite kind of boot camp. This is my favorite kind of interaction. I always call it stump the chump. I would be the chump and you're the stumpers. So send me questions that you don't think I can answer, and we'll muddle through one way or the other. This is our workshop room. So if you were to come to one of our regular meetings, we have all kinds of stuff. We have the illustration of how trusts work and how probate works. This is a state recovery right here, in case you were wondering. This is hourly bill, you know, how attorneys get paid for probate court, all the rest. These are the three elephants that everybody's hiding from you, the elephants in the room that people are trying to put bed sheets over. I can explain that if you'd like, but I've got some questions, so let me get right to it. Judy DeCourt. All right. Crank up the volume. I don't know. Can you hear me now? Hello.
We can hear you, but it's it's showing the shopping cart, and we're not seeing you.
All right.
Perfect.
And is the microphone on? Do you have the
We can hear you clearly now.
Okay, very good. Well, my only concern is that it's is the program feeding off the radio mic or the camera mic? Have you? Okay. Did you turn that on? Okay. And then that's microphone one, and that's showing there, and on program, so we're good to go. All righty. That will be our technical difficulties for the day. So from Judy, can we send collection letters to Medicaid pending residents who are not paying an estimated patient pay amount? Charge on, go right ahead. Of course, they owe you the money. Yeah, why not? Even if they're Medicaid pending, because how many Medicaid pending turn into Medicaid denied, right? So yeah, and you're entitled to the patient pay amount, whether they get approved or not. Now, if it's a married couple, maybe the patient pay amount, there's a community spouse income allowance, so the patient pay amount is less than you think it's going to be. But I would not hesitate. How do we get the information needed from insurance companies, pension companies, and banks when they will not work with you or the family? It seems that once a person passes away, it is more difficult to get Medicaid to be approved. Any suggestions or advice in a situation like this? So number one, how do you get the information? There is no easy answer. No easy answer. Unlike any other law firm I'm familiar with, in order to make sure our trusts work, we have to retitle assets into the trusts, okay? What that means is we have to work with all these people you're talking about, insurance companies, banks, financial advisors, the rest of these people. It is excruciating. It takes months to make sure that assets are put into trust. This is why most trusts fail. Most attorneys don't even try to do it. Most law firms, the big law firms downtown, forget about it. They're not funding the trust. This is why the estate plans fail, okay? Which is not your situation. You're just trying to get the information from them and find out what's going on. But my point is, we're dealing with the same players. We're dealing with the same institutions. And the only way to do it is to keep beating your head against the wall until something breaks. And hopefully it's the wall instead of your head. But we have successfully funded, I don't know, 15, 20,000 trusts. We've got very good people with very hard heads doing this kind of work. There is no easy answer to it. I wish there was. I wish there was a magic wand, but you can have a court order and still not get the information from some of these people. You know, they just shuffle it around. You're on hold forever. The funding department in in this firm it's very difficult, very challenging, very frustrating. We're totally with you on this. It's just a problem. If you have a real tough nut to crack, in the same way with our Medicaid department, they're going through the same things. because we're doing the Medicaid applications, and lots of times we're dealing with people perhaps with a little more of assets, but we're dealing with we're dealing with the same players. So it's tough when you're trying to provide 3 square meals a day, plus showers, plus laundry, plus heat, plus sanitation, plus everything else that you have to do to run a nursing home, and try to track this stuff down. I'm with you. Okay. That's where here's a unabashed plug, whatever. That's where we can help. If we're involved in it, all they do all day is beat their heads against the wall. They got a lot of knots up front there. So, maybe we can be helpful. I wish I had the magic wand. There is no magic wand. It's just, you just got to keep beating on it. And it is very frustrating. It seems that once a person passes away, more difficult to get Medicaid to be approved. Yeah, because they don't care anymore. And it's much less really with the Medicaid cases, with the caseworkers, because we do a lot of these where, nobody knows how long mom or dad is going to live, grandma, grandpa, nobody knows, but you're thinking it's going to be a while. And then sometimes, even before the approval comes in, they pass away. Well, now we got the whole trust administration thing going on. You got the probate thing going on. But, we've been very successful, frankly, getting Medicaid to cover for the past. But it is difficult to get the family involved. Okay. The family doesn't, they've moved on. They're doing something else now. And we're asking them for records and all the rest of it. Lots of times, many times, we have the same problem you do, which is, yeah, they retained us to do the Medicaid application, but now that grandma has died, right? Where's the percentage? Where's the profit in continuing to do the Medicaid application? Well, of our 3 elephants, the first elephant is our clients don't go broke. The second elephant is the nursing home gets paid. It's a big deal for us. And then the third elephant is the kids, right? But getting the nursing home paid, getting the caregivers paid is a huge, big deal for us, because we want good relationships with you guys. If we call up, we want you to answer the phone like that. We want you to see that we are partners with you in getting the pay. We're not here just to shovel everything to the kids. That is not the point. Okay. But we don't want our clients going broke either. That's number 1. Number 2, get you paid. Okay. Number 3, if there are leftovers, get it to the kids, which gets me to the last one, which is the kids don't care anymore. The family doesn't care anymore. And this is a real problem. It's a real problem because once the person has died, right, you don't have recourse anymore against the other spouse or against the family members. The only person who owes the facility money, generally speaking, the only person who owes the money is the person who just died. And typically there's nothing in their estate for you to go after. All right. And there's all kinds of stuff to be done in trust administration, probate administration. Okay. So we do try to get the Medicaid to cover for the facility. And we do remind the clients, but we're kind of between a rock and a hard place when it comes to that, because we have to give accurate information to the family. I had this conversation yesterday. Do we owe the nurse? Do we have to pay the nursing home? No, you don't. As a matter of fact, there is no legal obligation for the kids who are beneficiary on this or that or whatever. There's no legal obligation to pay. But we strongly advise that, we do, and, give the money to the foundation so that at least you get a charitable deduction from it. Okay. Those are difficult cases, very unusual cases, but they do happen because generally speaking, between pre-existing medical expense and Medicaid and paying the patient pay amount and all the rest, we've got the facility paid. But it does happen, and I'm with you on this, a very difficult situation. What if the resident, this is from Marlene Mead from Monroe. Marlene Mead from Monroe, Michigan. There you go. That's what we call alliteration. Anyway, if a resident admits and the family member in the process of becoming POA, stop right there. Stop right there. You've admitted them and they're in the process of becoming the POA. Listen, when we get somebody in here who's got questionable competency or they're looking at the long-term care, they don't get out until they've got a signed, sealed, delivered power of attorney for finances, power of attorney for healthcare. Okay, the idea that this is somehow in process is all kinds of red flags to me. I mean, who's doing it? Why isn't this done already? If you're talking about conservatorship, guardianship, and probate court, okay, I get that. But process for a power of attorney? What? I mean, we're not with like monks scrawling on sheepskin anymore. There are these things called laser printers and, you know, dot matrix and stuff like that. Anyway, so that's a red flag right there. Resident needs to apply for Medicaid. What powers will the POA have if the resident has a 401k, whole life insurance? Here's the thing you got to remember about powers of attorney. This is, everybody gets this wrong. Attorneys get it wrong. Family members, everybody gets it wrong, except us, which is why you're here, right? What everybody thinks is that the power of attorney is about, what they think it's about is paying the bills till the money's all gone. That's what they think it's about. And so you have very, what I would call weak powers of attorney that only allow you to write checks or sell real estate. None of that works when you're talking about Medicaid. When you're doing the Medicaid, and most of the powers of attorney we get, I don't care from the glass towers downtown to the guy who's doing it on the street corner in the shopping mall, okay? They're all about the philosophy. The idea is I need someone to pay my bills if I can't do it, which results in pay the money till the money's all gone. And there's nothing there to get them qualified for the Medicaid to do the things that are needed to be done. Now, the question here is, can someone using a financial power of attorney access the 401k, life insurance, and the other spend down assets? The answer is they should. They absolutely should. Does that mean that the power of attorney was written that way? No, it doesn't. It does not. All right. So the problem that you've got is not with the power of attorney. The problem that you've got is with the way the power of attorney was written. And this is the thing everybody gets wrong, in my opinion. They all get it wrong because they're not focused on what if mom winds up in long-term care. What they're focused on is mom can't sign her name, so I got to sign her name to the bills. And it's a completely different perspective. And so, you know, the consequences are completely different. Is it true only if they become conservator can they be allowed to cash out assets? No, that is absolutely not true. And in fact, as conservator, see, if you have power of attorney, you want to sell the house and it provides that you can sell the house, go ahead, sell the house, no problem. If you've got a conservator and they want to sell the house, now I got to go to probate court. Good luck for that in this environment. I got to go to probate court, have a hearing, and have the judge approve my selling the house or putting a mortgage on the house or selling part of the house or a land contract. All the real estate is typically, not always, but typically all of that is reserved until further order of the probate court. Okay. So is it better to have guardianship, conservatorship if you got real estate? Absolutely not. In fact, the best thing that people can do are what we call an enhanced power of attorney for healthcare, right? Which includes mental health powers, which, as you know, most don't. They just don't cover it. They're not thinking about it. It doesn't seem like a big deal. So it's got to cover mental health powers. And on the finance side, it's got to cover all the stuff that you would do to get qualified for Medicaid. So yes, 401k powers. Yes, IRA, 403b, 457, whole life, term life. All the rest of this stuff has all got to be in the power of attorney. And it winds up being a long power of attorney. Now, here's the thing. Most people, many people and again, I include attorneys as people, because sometimes they are satisfied when the power of attorney says, anything I can do, you can do for me. And it says it in there. Anything I can do, you can do. The problem with that is it doesn't work. That's not what the law says. The law says if you're going to have gifting powers, if you're going to have various management powers, you have to spell them out. And if you don't spell them out, you can't do it. All right. And that language, anything I can do, you can do for me. Isn't that I think that's a song, right? Anything I can do, you can do for me. Anyway, musical interlude. You're much better off with properly drawn powers of attorney than you ever are going to probate court, because now you got all the probate rules stacked on top of what you're trying to accomplish. Don't advise it. Oh, next one from still from Marlene Mead from Monroe, Michigan. This is one where you find out after the application that the guy's married. All right. And you find out, and this is part of the fact pattern here, then he admits. So you've admitted him to the skilled nursing facility, which means what? It means you can't kick him out, pretty much. And then found out he was married, but separated for 10 years. All right. Says that he was kicked out of a previous facility. You wonder how they managed that, right? Must have been assisted living, because that's not going to work in a skilled nursing facility, because he could not get Medicaid approved due to his spouse not turning in documents. Here's the deal. In Michigan, married is married is married is married. Okay. If you're married, then, and you have an institutionalized spouse, then hiding under the mattress, you've got a community spouse, and they're an asset control group of two. This guy's financial information is worthless unless you know what her financial information. You gotta know it all. Otherwise, what? Otherwise, you get denied. Okay. And if you've been at this game for 6 months or more, you know that. You should know. My opinion. You should know that. And instead, you know, you guys hired whoever it was you hired, somebody didn't know what they were doing, tries to get an exception to policy. Are you kidding me? An exception to policy. You know, when Moses parted the Red Sea, that was an exception to policy, right? But Moses had help. It was Aaron was there. Jehovah helped with that. You know, you see what I'm saying? It's that big a deal to get an exception to policy. And they give you the 3 reasons why you're not going to get it. And one of them, and the one I love the most, is a policy exception is needed based on unique and rare circumstances in a specific case to avoid extreme and unusual hardship. What the hell do you think is unique, special, hard? You know, there's nothing unique about this. It happens all the time. Okay. So in a situation like this, and let me warn you about attorneys who don't do this very much. Okay. There's a lot of stuff in the rules, right? Where if you don't really, you haven't done this very often, let's say, I mean, you haven't done it. So, okay, fine. You know, more in sorrow than anger, right? You haven't done this very much, and you read a rule, or you read this thing about exceptions, right? And you think it means that, right? Lawyers always they always think they can maneuver around it. They can make an argument or something like this and get around it. And that does happen in court quite often. It doesn't happen with Medicaid. All right. They mean this stuff. You know, for divestment, let's take an example. Divestment. It says that it's not divestment. It is not divestment if no part of the motivation for making the transfer for less than fair market value, if no part of it was what? What does it say? Motivated by qualification for Medicaid. So if no part of your motivation, no part, 0 part was to get qualified for Medicaid, then it's not a divestment. Right? And they have the example of the young man who paid his kid's college tuition, gets hit by a bus. Well, he didn't know he was going to get hit by a bus. And so, well, that's how they look at it. Okay. You get over a certain age, everything you do, according to a caseworker, is motivated by the desire to get qualified for Medicaid. Now, maybe it's a small part, but it's a part. I've got a case up on appeal right now where the caseworker is arguing that the woman who went into she was in the nursing home or about to be, I forget exactly which, and she gave money to the church and she painted her house. You with me on this? Painted her house, divestment. Because some part of that was desire to get qualified for Medicaid. Are you kidding me? See, if you don't know how the rules actually work, you would read that bit about, oh, no part of my, and I've seen this. Attorneys will do affidavits. Oh, no part of my intention was da, da, da. Do you think that works? Not if you've been down this road like once before, but you get there's a lot of stuff in there. And when you talk to attorneys about it, they think, oh, we can argue this, or we can argue that, or we can argue something else. That's what happened here. Okay. See, how many months did it take to go through this? Right? How many months? And what does it cost to be in your facility for a month? $9,000, $10,000? Well, for every month, there's another $9,000 or $10,000 you are never going to see again. Just gone. All right. If we get a case like this, you know what the first thing we do is? Get the divorce. Get the divorce. It's no fault divorce in Michigan. They don't even have to agree to it. Okay? Because everybody knows, everybody who knows, this is ridiculous. You can't convince them of this stuff. You know, you got the thing with, you got to show disability of the spouse, right? You got to show disability to qualify, you know, Social Security disability in order to get the benefits in some cases. Okay. What if you never made enough money to qualify for Social Security disability? Now you can't use the Social Security disability. You know how hard it is to get them to acknowledge that the person who's flat on their back and has been for the last 10 years is disabled if you don't have Social Security disability. And the reason you couldn't get Social Security disability was because they never had enough work credits to get on Social Security in the first place. It's crazy, but that's what you're dealing with. And if you've been dealing with this for a while, you understand that's what's going on. Okay. So remember, until death or divorce do us part. You gotta split them up. This is not a surprise that this went this way. Anyone who's done it before should know it. And the fact, and my question to you is, you know, what do we do about this character who probably has no money at all anyway? You know how difficult it is to get rid of somebody for inability to pay. I would say the way you get rid of them is fraud. All right. This guy knew he wasn't going to qualify. How does he know that? Because he already been down the road before and he didn't tell you till he got in. Okay. I would go scorched earth on this guy. This is not okay. You know, proceeded with collection letters, phone calls, 30-day demand letter. They're going to blow all that stuff off. Meaningless. What is it? Oh, I'm being advised to calm down a little bit. Chill out. Well, okay. But I'm serious. Look, you know what cheeses me? I'll tell you what cheeses me is the fact that most long-term care facilities have got, and you know better than I do, you know much better than I do, how many folks you've got who just aren't paying. You're not getting the patient pay amount. You're not getting the Medicaid. You'll never get the Medicaid because no one will cooperate with you because they don't have to cooperate with you. And there is no house for them to get and all the rest. And so you got all the facilities, and this is why your bad debt write-off is so enormous. And if you look at a public, you know, look at the annual reports from the long-term care facility, you will see bad debt write-offs are an enormous expense, right? This is money that you'll never get back. And you could have gotten it if somebody who was advising knew what the hell they were talking about when it comes to some of this stuff. And you weren't going down, you know, following the white rabbit down the hole of thinking, oh, maybe I'll get an exception or something. But you know what I mean? I mean, imagine, think about the people that you've got in your facility right now, who every month, instead of getting 10,000 or 9,000 or 12 or 15 or however much it is you charge, right? Instead of getting that, Instead, you're going in the hole every month, every single month. Well, what if you got two of those people to pay? Now you got $20,000, $30,000 more a month in your budget. And you know better than again, you know this stuff better than I do. But what does it take to keep a staff person? How much money does it take for a staff person to go from and you recruited them and finally got them on board and you got them trained and you went through the drug screen, you went through everything, right? You got them on board. Somebody offers 25 cents more an hour and they're gone. Well, if you had per patient $10,000 a month for everyone who's not paying you right now in your facility, and you got them, multiply that times $10,000 a month. If you had that much more in your budget, right, would they even be looking for the additional 25, 50 cents an hour? I'm not saying everybody's like that. Some people are very dedicated and all the rest, but money talks and something else walks. And that's why I say, get the facility paid. You guys have got a real tough job out there, and not having money to do it just makes it worse. Okay. What else we got? One of the biggest reasons he's not approved, not filed for divorce. No kidding. He and his wife have been separated, given a lot of time to file, not permitted to make suggestions. Certainly explain that. Yeah, that's what the caseworker was saying. The caseworker is absolutely right there. Resident has over $2,000 in account. Can they spend some on home improvements to a house that his name is not on, but his spouse owns? It's stimulus money, so he can gift it to his wife or some of it to his wife. The good news is transfers between spouses are not divestment. Okay. So you could move $1 million from one spouse to the other. It's not a divestment. Now, if you're still in the presumed asset eligible period, the 13 months from the processing month, right? Now, after you submit the application, there's still an asset control group of 2. As a practical matter, okay, once you get the approval, they're treated as asset control groups of 1 and another asset control group of 1. So after you get the approval, they don't count her assets against his. But that's not the law. That's the practical, right? As a matter of law, it's not until the case is redetermined, until the end of the presumed asset eligible period, right? Until that time, they're considered an asset control group of 2. And theoretically, although I have never, there's one case 25 years ago, except for this one case, they don't look for the community spouse's assets after the approval, even though technically they still are an asset control group of 2, and they don't become an asset control group of 1 each until after the expiration of presumed asset eligible.